Good day, everyone. Eric Olsen from Helps, law firm for seniors and disabled persons. Good to have you here on Monday, February 23rd. My name's Eric Olsen, attorney for 48 years, the founder of Helps. Helps is a national law firm. Our mission is to protect seniors from debt collector harassment, and we also want to educate seniors how they can maintain their financial independence. So I want to welcome you to our website and to uh, our YouTube channel. And if you have any questions, you can put them in the chat feature, um, and I'll address them there. And then I've got a lot of things that I've written out that people have asked us over the last few days. I'm going to talk about that. Okay. Um, Person contacts us. They say, I've been unable to keep up with the high cost of everything. I resorted to credit cards uh, to keep up with the daily needs. Now I can't keep up with payments. Can you help me? Help me Can you help me one more time? I won't do this to myself again. Okay, I think this was a helps client that wrote this in. Um, Let me explain. Okay, first thing, if this is your first time listening to me, uh, I just want you to know that if you get Social Security, pension, disability, VA benefits, virtually any form of retirement, even your 401k or your IRA, those monies are protected from debt collectors. They can't be taken from you. Okay, they're available for your needs, for your food and your medicine. Okay. um, and for whatever else that you need. The creditors can't take it. If a creditor were to sue you and file a lawsuit and get a judgment against you, the money's still protected. It can't be garnished. What about when it's deposited in your bank account? Well, there's a federal law that went into effect back in 2012 that tells a bank or a credit union if they get a writ of garnishment, someone sues you and they have a judgment, then they can garnish your bank account. However, if a bank gets a writ of garnishment and if they have to examine where your money came from, and if it came from a federal source like Social Security, a VA benefit, a federal pension, uh, like post office or a VA pension, railroad retirement, then they, especially Social Security, they take the amount you get each month times two and protect that automatically from garnishment, regardless if there's other funds in the bank account, no matter where they came from. So if you got 1,500 in Social Security each month, then 3,000 in your bank account is going to be protected from garnishment by your bank without you having to do anything. Okay. So this person that contacts us from Helps, when you enroll in Helps, you give us your credit bureau money too. We send a cease and desist letter. But for whatever reason, this person started using some credit cards again. Now, if they had debt that they didn't give to us originally, because they're our client, when you enroll with Helps, you're our client ongoing. You can give us that new debt, and we're going to send a cease and desist letter out to that new debt collector. Okay, and they're going to leave you alone. Okay, and what we do is there was a law passed in 1978 called the Fair Debt Collection Practices Act. That law provides, in part, if you're represented by an attorney, debt collectors can no longer call or send demand letters anymore. They have to deal with the attorney, and that's what we do. When people find out about Helps and they enroll in a program, they give us the creditors they owe money to. Excuse me. We're going to send out a cease and desist letter, and they're going to leave you alone. Okay. Um, they can't call you or send you demands anymore. Okay. Now, that law doesn't apply to original creditors. An original creditor could still contact you, but normally we will send a cease and desist letter out even to an original creditor. They're going to leave you alone. They may continue to send you a bill. If you're in a client of Helps, you can do a change of address on the bill to have the bill sent to your name, care of Helps. Okay. Um, so there's a lot of misinformation or not complete information given to seniors. So I'll give you an example, okay? And this is all over. It's ubiquitous, okay? Okay. Here's a website for financial strategies for seniors in debt from the Financial Counseling Association of America. And so it's directed to seniors. And it talks about the type of debt, medical debt, housing debt. So this is okay. If you have, let's look at what this website does. If you have medical debt, your smart strategy is to negotiate their price or provide discounts, or housing debt. Talk to a trusted financial advisor to discuss whether downsizing or taking out a reverse mortgage. Reverse mortgage could be okay. Credit card debt. Don't hesitate to get help with your credit card debt. A nonprofit credit counseling agency can help. Um, it says many scammers try to steal seniors' money by offering debt assistance. Choose a nonprofit credit counseling that is a member of their organization here. Okay, now let me talk to you about this for a minute. Like I said, I'm 75 years old, been an attorney for 48 years. Helps was started in 2012. Companies that assist seniors with debt management, if they're profit or nonprofit, either one, with rare exceptions, there are exceptions, they won't tell seniors this one fact, that their Social Security, their pension, that their disability, their VA income is protected from debt collectors, and that you don't have to pay it, that they can't take your Social Security, they take your pension. So if you follow this company's advice that we just looked at, and you contact a nonprofit credit counseling agency about your debt problems, I talk to seniors every day that are signed up with nonprofit debt management companies and for profit, either one. And I ask them, did they ever tell you, by the way, Mr. Jones or Mrs. Jones, your Social Security is protected. So is your pension. No one can take it. And you can choose not to pay this debt. And there's a way to stop the creditors from bothering you. No, Mr. Olsen, they never told me that. Well, if they would have told you that, you wouldn't sign up with them and they wouldn't be making money off you. The nonprofit ones make money, and about a third of their clients, a lot of their clients, I think up to a third of them are seniors. And if they were to tell seniors the complete truth, they'd cut a substantial amount of their income out. So let's go back to this website. I'll look at it some more here. Um, Organize financial information, build a better, but nothing wrong with doing that. Get help from a professional credit counselor. Once again, if you do that, these credit counselors aren't going to tell you what I'm telling you. The fact that your income's protected, you don't need to pay the debt out. And that's kind of it. Let's see what it say next here. Okay, whatever. That's from the Financial Counseling Association of America. So some of these nonprofit companies are enrolled with them, and but they don't tell them the complete truth. These debt management or debt settlement companies, the profit and the nonprofit ones. Test me out. Look up nonprofit debt management. Read what they say. They read what they say. So they'll tell you some things that they're scary enough that you're going to want to call them. But when you talk to them, they're not going to tell you the fact that you don't have to pay the debt, that they can't take your Social Security and how your bank account is protected and the stuff you're going to hear from me today. So Miss H says, after help sends a cease and desist letter out to a creditor, can they many years later still contact you after the statute of limitations run out and have not filed a suit against you? well, not legally, but they do it. Creditors or collectors often try to collect a bill after the statute of limitations is expired. So what does that mean? Statute of limitations means that under a state law, they have a certain number of years to file a lawsuit to collect the debt. Um, could be as soon as 3 years, but typically 5 to 6 years. Now, and it usually, the statute of limitations runs from either the date when you incurred the debt or when you last made a payment towards the debt. So if you made a payment a year ago and the statute of limitations is 5 years, they have, 4 more years to sue you. Um, but let's say it's been 10 years since you made the bill. It's a real old. Legally, they could still contact you and ask you to pay the debt. They just can't sue you or even threaten a lawsuit. I've seen a number of letters that clients have forwarded us from collections that are old. A few of them say at the end, by the way, we can't sue you because of the statute of limitations, but we'd still like you to pay us. Okay? But once again, if you're a senior and get protected income like Social Security or pension or disability or VA benefits, you don't have to worry if you're sued. Okay? They can't take anything. They can't take anything from you. Income's protected in your bank account. You're going to be fine. So you don't need to worry. Person from Pennsylvania contacts us and they say, I received a statement of claim letter from an attorney offering to represent me in court at my court hearing on May 18th, 2026 for Discover card balance that I owe in the amount of $9,100. I am retired, living only on Social Security of $16.58 per month. Do I have to go to court? Well, the answer is no, don't have to go to court. Well, why did you get a letter from an attorney offering to represent you? Well, if you read the letter carefully, it's probably offering bankruptcy services. A number of bankruptcy attorneys subscribe to a service that lets them know if someone filed bankruptcy. And then what they'll do is they'll send a letter out to that person. Um, they'll subscribe to a service and let someone know if someone's been sued. And so they send a letter out to that person who's been sued offering, tell them, tell them about bankruptcy. Some people will get half a dozen letters in the mail from different attorneys. A lot of people call me and talk to me and say, it looks like I've been sued. I don't know anything about it because they get the letters before they were served with the paperwork for the lawsuit. Um, so, um, so what we'll tell this person is, you know, we'll tell them about helps. And if they decide to enroll in helps, we'll tell them, um, you know, we won't contact the attorney that sued you until you get served with the papers. We'll probably send a letter out to Discover, let them know that you're not going to pay the debt. But when you get served with the legal papers, just let us know. We'll send a letter to the attorney who sued you. We'll let that attorney know that your income is Social Security, it's protected, that you can't afford to pay the debt, you're not going to pay the debt. And then we're going to call you on the phone and explain why you don't need to go to court, why you don't need to worry about this, why your assets are protected. That's what helps does. Okay. Now, attorneys always haven't been able to do that, send letters advertising their services. Um, the law changed way back in 1978, the year I graduated from law school. And at that point, before that, attorneys couldn't advertise. If you look at the yellow pages from 1977 and before, um, the listing for attorneys, it just had their names and numbers, and that was it. No advertisements. And then for many years after 1978, attorneys started advertising in the yellow pages. Okay. And at one point, the largest group of advertisers in the Yellow Pages was for attorney ads. Okay. There was just lots of them, tons of them. Now, the phone books have gone by the wayside. So whatever phone books out there, there might be a few ads, but no one has a phone book anymore. They don't need one. So where do the attorneys advertise? The internet, okay? Or in this case, a bankruptcy attorney will send a letter. There's certain things it has to say according to the state. Billboards. They advertise on billboards. I live now for a few years now in New Orleans. About every third billboard is an advertisement for a personal injury attorney. Now, I've been here for almost a year. One thing I noticed when I drove here is I told my friends here in New Orleans that, the drivers here are pretty courteous. And I think the reason is they read these billboards, and every third billboard is advertising for a personal injury. If you're in a wreck, call this attorney. These attorneys must pay, I don't know, hundreds of thousands of dollars in fees for all these billboards, millions probably. Some of them do. That's a lot of billboards. Uh, and so, attorney advertising is pretty prevalent nowadays. Used not to be in existence. When I first became an attorney in 1978, I started to practice on my own. I worked for a good firm, and they offered me a job out of law school, but I wanted to go back to my hometown, and I decided I wanted to be my own boss. Okay. And that first year I practiced, I saw that there was advertising. So on that phone book, I put in a little one, like a 2 sentence ad. All I put in was, it said, initial consultation, no charge. Okay. And if I remember right, I was probably the only attorney out of maybe 60 or 70 or 100 or so attorneys that had a little blip in there. And that was just it. I always thought that, you know, someone should be able to call and talk to an attorney and ask him a question without having to face a bill. And so I decided I'll do that. And my phone started ringing. People would call with questions. But that's why you got that letter from an attorney that you've been sued. You don't need to worry. Your income is like this guy. He says, I'm retired, living only on Social Security benefits. If they get a judgment, they can't take his Social Security, protected in his bank account, as I explained. He's going to be fine. And like Turbo says, you can always ask your questions. I like questions. I know a lot of you listen later, so they can't ask the questions. If you're listening at this later, call us on the phone. We got paralegals standing by and attorneys to be able to talk to you and ask your questions. That's the whole purpose of HELPS. I probably filed 30, 40,000 bankruptcies before HELPS was started. And HELPS was started because, I talked to seniors and explained to them, hey, you can't afford to file bankruptcy. You don't need to file bankruptcy because your income's protected. But I knew that creditors would harass them. And so under HELPS, they can be represented by an attorney, and we send out what's called a cease and desist letter, and the debt collector has to leave them alone. So that's what we do. And we represent seniors ongoing, not just one time, literally for the rest of your life, so you don't have to worry. There is a very modest cost involved with HELPS. Maybe 1 out of 5, 1 out of 6 of our clients get our help for free. Of all our clients, I imagine close to half get our help for free, because I'll explain why. The most a person would pay would be $40 for the first 24 months, then $20 for 24 months, then free thereafter. Or it could be $30 for 24 months, $15 for 24 months, free thereafter, or $20 for 24 months, $10 for 24 months, free thereafter. Remember, when you enroll in HELPS, you stop paying this credit card debt you don't want to pay and other debt. Okay, and then you can always call and talk to us. We're there literally forever, so you don't have to deal with creditors. So here's someone contacts us from Rhode Island, and she says, I'm an 83-year-old widow of 30 years. I held onto my home as long as I could. I sold the home and rented, which was a mistake. Maybe, maybe not, but for her, she thinks it's a mistake. I'm $40,000 in debt, which went up from $27,000 because I can't pay them, and the late charges and interest are climbing out of sight. I just moved to Section 8 housing on December 1st, 2025. What's Section 8 housing? So if your if your income is under a certain amount, there's a federal program called Section 8, which will pay part of your rent and essentially charge you about a quarter to a third of your income for rent. But the supply is less than the demand, and so there's a waiting period. It could be up to 2 years or even maybe even longer. And a lot of times I'll tell people, tell them about Section 8, suggest they sign up for it. Some say, well, I don't want it. I say, well, sign up for it anyway. Maybe in 2 years you might decide that you'll be glad that you signed up for it when you did. But she's on Section 8 housing, so she's paying a small amount for her rent. Okay. I fear my credit rating will force them to evict me. No, as long as you pay your rent, your credit rating is not going to have anything to do with your ability to continue renting under Section 8. I don't think I should file bankruptcy. You don't need to file bankruptcy. All your income. I live on Social Security of $2,400 a month after Medicare plan, after Medicare Plan D is deducted. She says, I listened to your February 20th, looks like last Thursday, podcast tonight and heard you say my Social Security is protected. It is. It is direct pay to my bank and I use auto pay. So twice the amount of your Social Security deposited in your bank account is protected by your bank in the event of a judgment from a creditor trying to garnish it. So if this person gets $2,400 a month, $4,800 in their bank account is protected. And heard you say that I might give them permission to access my money in my checking account. I have a 7,000. Okay. The only exception would be, let's say if you gave authority to someone to take money out of your bank account, then yeah, you've got to cancel that authority. So if you gave authority to a credit card to take money out, you've got to cancel that. Now, if you bank at a credit union and you owe the credit union money, then that credit union, whether you realize it or not, you gave them authority to take money out of your account where Social Security is deposited. So if you owe money to a credit union, you decide not to pay it, you need to cancel the credit union and have your money go into a different bank where you don't owe money. Now, the only other bank that would do that would be Truist Bank. They do that. Just credit unions and Truist Bank. Regular banks, if you owe them money, they don't require you to sign a form that says that they can authorize you to take money out of your account if Social Security is the only money going in. She says, I have 7,000 in a CD I put aside for my children to bury me. I don't want to lose that, but I don't know what to do with it. Well, okay. You don't have to worry about anything unless someone were to sue you and get a judgment. Now, if the CD, if you could be able to prove that the money came from a protected source like Social Security, if they were to garnish it, you could get the money, get the court to order it be released, or you could cash out the CD, put it in the kid's name, put it in cashier's check, uh, um, or preloaded debit card. There's things you could do. Okay. And she says, looking forward to hearing from you. Well, I'm sure we've already called her, or we will be calling if we haven't already. Uh, I hope my connection is okay for everyone. If everyone's having a problem or not, I hope not. So this person contacts us from Iowa, and they say, I'm very interested in your services and how they work. I'm on Social Security dealing with health issues. I appreciate whatever you can do to show and tell me about your services. Well, that's what we're doing here. And we're answering other questions as well. So what happens when you call helps, we're going to ask you some questions. We're going to ask you, where you live, what state, married or single, your age, um, buying a home, renting, buying a car, own a car. Have you been sued? Um, what do you think you owe your creditors approximately? Basic questions we need to be able to give you information about your situation and what your rights are. It's not that we're being snoopy. We don't ask any snoopy questions. At the end, if you decide to enroll, then we're going to ask a couple more questions. Um, for example, at the end, we're going to need like your mailing address. I need to know the last four digits of your social security number, because sometimes when we enroll someone, a creditor will call us and they'll want to verify that we actually represent the person, and the last four digits of your social security number, we give that to them, then they know that we've actually talked to you. Um, we like to know your date of birth. Sometimes that's important. Um, and then Jerry asks, who makes the determination of what you pay to helps? Well, it's kind of a guideline on our fees. Depends on what your household income is, um, and also some other factors as well. If someone calls us, for example, let's say a son calls on behalf of his mom and she's in assisted living, and all her Social Security and all the money is going to pay to assisted living, and she has debt, and maybe she's on Medicaid. She's getting $50. We don't charge her anything. We'll sign up the mom. She's not charged anything, and so it depends on a lot of things. The most a person would pay would be $40 for 24 months, $20 for 24 months free thereafter, or $30 for 24 months, 15 for 24 months free thereafter, or 15 or $20 for 24 months, $10 for 24 months free thereafter. Um, it's kind of a sliding scale, and we make it work for people. Um, the only reason we charge is, we've got a staff that we have to pay. We have to pay for our phone lines. We have to pay for mail. We've got costs involved, and we're growing too. Um, so we make it work for you. And and it's not cut and dried. We don't, you know, there's always exceptions. You got to realize when people enroll helps, a lot of times they've been paying hundreds of dollars on their creditors, and then we call helps. Now all of a sudden they don't have to do that anymore. So things change a lot. And then the nice thing about helps is, normally when you hire an attorney, you hire him for a specific reason to do a specific thing. But with helps, we're there ongoing, literally for the rest of your life. So you give us the creditors you don't want to deal with anymore. We send them a cease and desist letter. They got to contact us. You can always call us with your questions. And like this person I talked to at the beginning today, they called me feeling kind of guilty because they had some more credit cards that they had incurred. Yeah, if you have debt that you didn't give us originally or that you incurred for whatever other reason, you can always add those into helps. So let's say a husband and wife, just the wife enrolls in helps. And then later, a year down the road, the husband realizes he can't deal with his debt. We can add him in, there's no extra charge. So we make it work for people. I'm worried about my adoption assistance. Okay, there's debt that's paid that's protected. There's income that's protected under federal law, and there's income that's protected under state law. I can virtually guarantee you that the adoption assistance is going to be protected under state law. Okay, but let's say for whatever reason it isn't. Okay, in 48 years of practice, I can't ever recall, in 30, 40,000 bankruptcies, I can't ever recall anyone talking to anyone that was getting adoption assistance that was having it garnished. You know, Why would lawmakers allow that to happen? They wouldn't. But let's say the law allowed it to happen. Well, if the adoption system goes into the, the account in which your Social Security is, twice the amount of your Social Security, let's say 2,200 times 2 is $4,400. Twice the amount that's in that bank account in which your Social Security is deposited is automatically protected regardless of where the money came from. So if you got $4,400 protected in your bank account because 2192 or $2,200 times 2 is $4,400 is protected, and your Social Security and your adoption assistance is 1,300, as long as you keep it less than 4,400, that money from the adoption assistance is protected in the bank account. Can they adopt it? Can they garnish the adoption assistance directly? No, I would be shocked beyond belief. No, it depends on the state. They're not. I guarantee you the state isn't going to allow that to happen. Okay. Good morning, Eric. Thank you for helping me create a life I can enjoy. Well, I appreciate that. That's what we want to do. Um, I don't care if you ask questions over again. That's what we're here for. And my favorite story on creating a life was that old guy who told me, who asked me years ago when health was new. He said, "Now can I buy? I can buy a present for my grandson now." Yeah, we should all have a life. So this person contacts us from Alabama, and they say, "I have a credit card debt with Wells Fargo that I was just served the summons on February 22nd, yesterday. They served you on Sunday, which is unusual. In which I'm supposed to respond in 30 days. I need to speak to an attorney about my options. Thank you." Well, okay. Yeah, if you owe the debt, okay, if you don't owe the debt, you could file an answer and contest the lawsuit. But if you owe the debt, you're getting Social Security or a pension, like I've been talking about, you don't really need to do anything. Um, if you read the paperwork, it says you can file an answer if you want to contest the lawsuit. If you don't want to contest it, they're going to get a judgment. But once again, they can't take your Social Security, they can't take your pension, they can't take your VA benefit, can't take your federal, your 401k, your IRA, the retirement incomes, and it's also protected in your bank account. So if you talk to helps, what we're going to do is ask you questions about your financial situation. If you decide to enroll, you're going to give us the creditors to whom you owe money. If you've been sued, we're going to ask for a copy of the lawsuit, usually the first 2 or 3 pages. We need the name of the attorney and the case number. And we're going to send a letter to your creditors to whom you owe money, let them know that you're not going to pay it anymore, not to bother you. We're going to send a letter to the attorney who sued you, letting him know that your income is protected. We're going to remind the attorney about the protected nature of your bank account, although it doesn't matter, it's protected no matter what. Okay? Okay. So this person says, "You contacted me by phone a few months ago from California. I want to let you know that most of my debt is now in collection so we can start the process. Please get back to me when you can. Thank you." You don't have to wait till you're hounded by creditors to call help. You can do it. You could do it. If we have 5 people call, maybe one is being sued, 3 or 4 out of the 5 are being harassed by creditors, and 1 out of 5, they're completely current on everything. They're completely current on all the debt. Um, um, it doesn't matter where you are. Now, the Fair Debt Collection Practices Act, which is the law which we operate under, provides that when you send a cease and desist letter, that compels a debt collector from contacting you. But there's 7 states that have taken that law and also included that as original creditors. But it's our experience that if we send a cease and desist letter out, we're going to send it out to whoever you give it to. Even if it's an original creditor, they're going to stop calling you. Now, an original creditor may still send you a bill. If you don't want the bill, we'll tell you to do a change of address, have the bill sent to your name. Care of helps with our address. So you don't need to wait. You don't have to wait till creditors are starting to pick up the phone and call you. Some people do. Some people call us two, three, four, five, six, seven, eight, 9 times before they decide to want help. Some call us, a year or 2 or 3 years ago, and then they call us every 6 months, and then finally they realize they can't deal with the problem anymore, and then they enroll with helps. Doesn't matter who you are, where you are. So this person contacts us from Virginia. His wife is under hospice, and I don't know how much time is left. So what's hospice? Hospice is the most wonderful federal program there is under Medicaid. And what hospice is a federal program that is if someone is supposed to pass away within the next 6 months, the government will, it is so amazing, hospice is. It will help take care of that person for those 6 months. Sometimes there's hospice agents has a place where someone can stay, but usually people stay in their own home, and a nurse will come by at least once a week or more often. They'll pay for pain medications, okay, and to help, maybe put a new bed in there, maybe send someone in. There's different uh, CNAs that come in to help maybe bathe a person or help someone take care of someone. So hospice is a wonderful benefit. So this guy, his wife is on hospice, and someone's helping him, which is wonderful. Doesn't cost him anything for this to happen. My wife was a hospice nurse for almost 2 decades. I used to help drive her around on Sunday nights. And the only problem with hospice is a lot of people may have enrolled in hospice longer, too late. They're only in it for a few days or a week or two when they could have had it for a lot longer and things would have been a lot easier for them. But don't get, if hospice comes up for either you or a friend, don't be scared about it. We're all going to die, and hospice is a wonderful blessing our country has. Absolutely incredible. He says, I'm her husband, and her illness has hit us hard financially. I've separated my income from hers so she could get medical help. She's only getting Social Security. Um, she's being sued by, and he lists whoever's suing her. I've talked to the court but told to reach out to an attorney. I've done so, but have been ignored. Gave them the contact to hospice. Well, hospice isn't going to help. Okay. I don't know what to do. She deserves to be left alone and let what God has planned out for her. Absolutely. Amen. She deserves, I know there is a homestead law in Virginia, and I have no idea I need to do to protect her. There are other collections, but they went from not trying to communicate to a lawsuit. I'm guessing law firm bought the debt. My cell phone number is, and I will take a text. Please help her. Well, of course we're going to help you and help your wife. So what are we going to do? We're going to call this guy back, and if his wife wants to talk to us part of the conversation, that's great. If we can enroll her in helps, we'll send a letter to the attorney that sued her, let him know that her only income Social Security. She's not going to go to court. We're not even going to mention hospice. It's none of their business. We're going to tell him that he doesn't need to worry. Now, it appears that he owns the home jointly with his wife, which means that when she passes away, the home is going to be in his name only, and that judgment from that lawsuit is going to go away because at his death, the home will transfer to the husband. He won't have to worry about paying it. And we're going to tell both of them they don't need to worry. They can concentrate on other things. And if they get sued by other creditors, they're going to give us those other creditors. Now, yeah. So if anything I'm talking about is a situation that applies to you, don't hesitate to call us. Press the like button, subscribe to our channel, Uh, a lot of people find out us by looking at these YouTube live videos. And there's just like this person, he didn't know what to do. He didn't know what to do. And the beautiful thing about it, he doesn't need to do anything. And, with helps, you have someone you can always call with questions. So this person contacts us from Missouri. He says, I fell behind in a debt buyer, Midland Financial, for Destiny credit card and Resurgent for Surge and Fit credit cards are harassing me. I've sent each a certified letter to cease and desist. You can send a cease and desist letter yourself. It doesn't need to be certified. He says, Midland has stopped, but Resurgent keeps sending me letters. I explained that I'm 71, my Social Security benefits and civil service government is protected by law. Um, Resurgent told me I could not get a validation of debt and not sent something. So he's trying to argue with them, have them go through some rigmarole. Uh, I'm going to send them a final notice of harassment so I can sue if they continue without following the debt validation procedure. Reporting my credit reports, I need help stopping them from harassing me. So, yeah, a person can send a cease and desist letter out themselves. We have a template on our website, or you can just Google it. A lot of seniors don't want to do that for this very reason. A lot of creditors kind of ignore it if they get it directly from a senior. A lot of seniors aren't in the position to print it out and send it. And then, but I would tell this guy, if he wants our help, we'll send a cease and desist letter. They're going to leave him alone. They know, helps has been around long enough. Debt collectors know who we are. We represent thousands of seniors that have these problems, many, many, many thousands, and more all the time. Person contacts us from, uh, I don't see any more new questions. Okay, my hair looks good. So what? Ask me some questions. I want to know if it's stuck there. Okay. Um, Person says, from Michigan, I'm being sued $5,100 for an old credit card. I have no assets and am disabled and collect Social Disability. Where do I go from here? You go about your business and you quit worrying about it. Now you're being sued. Well, um, your only income is Social Security Disability. It can't be taken. It's twice as protected in your bank account. You can't take your Social Security Disability. You don't need to go to court. If you want our help, you're going to call helps. You're going to give us that debt plus all your other debts. We're going to send out a cease and desist letter. These creditors are going to leave you alone. We're going to contact the attorney who sued you. Tell them, go ahead and take your judgment. Tell them that your income is protected. They can't. We're going to call you on the phone, explain to you why they can't touch your income, why it's protected in your bank account, and why you don't need to worry. Would I happen to have the list of the 7 states? I'll try to talk about that tomorrow. I can't remember off the top of my head. But, in some ways it doesn't matter because when we send out a cease and desist letter, it's my experience with helps is that no matter what state you're in, if it goes to an original creditor, which we do, they're not going to call you on the phone. Now they may continue to send you a bill, but they're not going to bother you on the phone. Okay. Person contacts us from the beautiful state of Oregon. He says, I've been unable to keep up with high costs of everything. I resorted to credit cards to try to keep up with my daily needs. Now I can't keep up with the payments. Can you help me one more time? I won't do this to myself again. That sounds like the same one that I opened the segment up today on. Could be the person asked the question again. So this person asks, okay, but what about money above 2 times the amount I get each month? Is that at risk? Uh, no. When I talk about twice being protected, I'm talking about twice being protected automatically without you having to do anything. Now, if you have more than twice that in there and it came from Social Security or protected amount, then the excess could be held up and you'd have to file what's called a claim of exemption or challenge of garnishment with the court, and the judge would order that money be released. This rarely happens with a helps client, but when it does, we're going to contact the attorney and we're going to let him know